Good morning. We start with the first panel. Wanted to welcome everybody back to this great event to consider the evolution in this next panel, how we got here, the evolution of antitrust law and the consumer welfare standard and the contributions of Judge Bork. And we have a great panel to discuss how we got here and where we're going. With us today, and I'll start from my former colleague from the Justice Department, Professor Elyse Dorsey, who is a visiting scholar at the University of Virginia and an adjunct professor at George Mason University's Scalia Law School. She previously served as counsel to the Assistant Attorney General in charge of the Antitrust Division and an attorney advisor to the FTC Commissioner Noah Phillips. Elyse earned her law degree summa cum laude from the Scalia Law School and served as law clerk to Judge Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. Next is Professor Michael Katz, who is the Sarin Chair Emeritus in Strategy and Leadership at UC Berkeley's School of Business, and also served as the Deputy Assistant Attorney General for Economics at the DOJ's Antitrust Division from September 2001 through January 2003. He directed a staff of approximately 55 economists and oversaw the analysis of economic issues arising in both merger and non-merger enforcement. Dr. Katz holds an A.B. summa cum laude from Harvard University and a Doctor of Philosophy from Oxford University, both degrees in economics, and one of the most sought-after experts in many competition cases in the U.S. and abroad. Last on the panel is my old colleague from his past administration, Professor Bilal Syed, who's most recently the director of the Office of Policy Planning at the Federal Trade Commission. Before his service, Bilal was an attorney in private practice representing clients in mergers and non-merger matters before both the FTC and the DOJ, and in consumer protection matters before the FTC. Bilal has taught antitrust law as an adjunct professor at the Scalia Law School at George Mason University and served as an attorney advisor to FTC Chairman Tim Muris. How we will proceed today, we'll ask each of the panelists for a 5 to 8 minute opening to share with us their views on the topic of today's discussion, and then we'll engage in hopefully a heated and debate about where we stand today, especially since most recently both the Wall Street Journal and New York Times seem to be discussing whether or not antitrust is a policy at war with itself or no longer at war. Why don't we start with Elyse?
All right. Is this on? Okay, yes. All right. So thank you so much, Macon, and thank you to the Federalist Society for having me here today. It really is, I think, a really interesting time in antitrust law, and poignant almost how much, again, we're having a lot of the same conversations that led to the publication of the Antitrust Paradox almost 40 years ago. So I thought I would start our discussion today, just kind of with some background, because the publication of the Antitrust Paradox was really the culmination of decades worth of work, which was by no small means, Judge Bork's contributions here were tremendous in many ways, but it wasn't just Judge Bork. There was, as he pointed out, antitrust was a policy at war with itself, and this was something that had been, under the microscope for quite a long time leading up to the publication of the book. So, we go back, to the original inception of the Sherman Act. It's, very broad, very general. It leaves a lot up to the courts to figure out how to make this workable, right? The Sherman Act says all restraints of trade, anything in restraint of trade, is going to be unlawful. Well, what does that mean? Because anything, anytime you enter into a contract, is going to restrain trade in some way. So there was really a lot that was left to the courts to make this workable, and they struggled with it for a long time. And looking at the legislative history as they did early on, and as many have done since. And again, it's one of these things we're seeing again today, a lot of the same conversations that we had earlier in terms of, okay, so what does the legislative history tell us? Can it tell us anything interesting? And, there's that quote that I think was it Justice Alito maybe, had said that, looking at legislative history is often like looking out at a crowd and picking from amongst your friends. You can often find whatever you want to in it. And I think the same is true in the Sherman Act, as we've seen. Judge Bork made very strong arguments that the consumer welfare standard is what was intended. Others have made strong arguments that, really antitrust should be socio-political. What I think is really more important and more informative is the actual history we have and what we've seen from courts and antitrust enforcers trying to actually implement the antitrust laws over the last, over 100 years at this point. And what we saw was when they were trying to incorporate all these different socio-political goals into antitrust enforcement, was it really led to a tremendous amount of contradiction, sometimes within the same case, but certainly across cases. And again, this was something that came up, several decades even before the Antitrust Paradox was published. So in 1966, for example, Justice Stewart, is looking at the case law in the Vaughn's grocery case. He finds, the sole consistency he could find in litigation under Section 7 was that the government always wins. And even Milton Hansler, who, was a respected antitrust expert and chief advisor on antitrust matters to FDR, who, is, when we think of trust busting, we often think of FDR. He criticized antitrust at this time as, an impenetrable jumble of words and embarrassing holdings and dicta that no one theory could fully explain, short of regarding the cases as fundamentally opposed to one another. So by the mid, 20th century, there's really, antitrust law is really at an inflection point. And so what we're seeing today, which I think, we'll get into as we get into, our debate a little bit later on, is, we have a lot of hearkening back to almost the golden era of antitrust in the mid-20th century. It was more aggressive. It was going after these socio-political goals. But when you're looking at what's actually happening on the ground in the case law, it's a mess. It wasn't a, political or partisan idea that it was a mess either. This was, everyone agreeing that antitrust law fundamentally was not working, and, us needing to kind of reevaluate, step back, look at first principles. What is it that we want antitrust law to do? What is it that antitrust law actually can accomplish, and how to, refocus it and make it workable in the world today? And so some of, what I think is very interesting, again, is, we have today we're having a lot of the same conversations we had a few decades ago. And I guess one of my main concerns, and I think we'll get into this as well, is, when we're talking about, how effective or ineffective antitrust law was in the mid 1950s, 1960s, leading up to the publication of the Antitrust Paradox, there was a lot of work that went into, kind of figuring out, okay, why isn't antitrust law working and how can we make it work better? And I think some of the calls to just return to the earlier era would be really expensive, costly for Americans, for the consumers, and across the economy, because what we saw again was, a lot of antitrust not accomplishing even the goals that it was trying to accomplish. It was not, really working for small businesses even. This was something we saw repeatedly in the case law as well. So I think I will stop there for now.
Thanks, Elyse. It's a good background about what really generated Judge Bork's views and motivated him to his great work, The Antitrust Paradox. Michael.
Go ahead.
It's off.
It's already on. All right. So I'm going to say a little bit, I think, about my sense of where we are now. And as is often my way, I think by the end I will have insulted everyone. So look, as we all know, as we said, we're in the midst of a great debate about the goals of antitrust policy. And to caricature the two sides of it, right, the left claims that the consumer welfare standard is too narrow and that coupled with economics has led to unduly weak enforcement. On the right, the most extreme claim would be that consumer welfare is the only approach that's consistent with economics and therefore is the only quote-unquote scientific approach. And moreover, that by using the consumer welfare standard, the courts have been doing a good job of basing decisions on sound economic reasoning. Now, in these polarized times, I think it's good to find common ground. So I want to start by identifying two things that I think the sides have in common. So the first is I think they're both fundamentally incorrect on important aspects of the debate. I think the left mischaracterizes what the consumer welfare standard is, or at least my view what it should be, and also mischaracterizes the role of economics. And on the right, I think they far exaggerate the link between economics, or at least the link between sound economics, and the consumer welfare standard in practice. Second thing they have in common is that both sides routinely make false economic claims and get the facts and logic wrong. And to get some economies of scope, let me talk about one error that both sides make in common. Both the left and the right subscribe to the false claim that a monopolist does not have incentives either to pass through cost savings or engage in innovation. Now, people on the left, a bunch will say, well, of course we say that, it's true. I suspect a lot of people on the right would say, wait, I've never said that. But in fact, it is becoming a standard claim on the right as well, because it's what underlies the false assertion that's frequently made that if a firm's quality-adjusted prices are falling over time, it must not have market power and not be a monopolist. And that actually is the same statement as saying that monopolists don't pass through cost savings or that monopolists don't innovate. Because, of course, there are lots of reasons prices can go down, including falling costs and innovation. And that's hardly a proof of the absence of market power or being a monopoly. I mean, one way to think about it is suppose IBM, hypothetically, had cartelized the market for personal computers and froze things in 1981. And so suppose we fast forward to today, and we say, look, a personal computer is still for around $1,600. You can still get a computer that has a clock speed of just under 5 megahertz, and it has a whopping 4 kilobytes of memory, and it costs the same as it used to. So obviously we don't have market power. Maybe we even lowered the price $100. Well, of course, the fact of the matter is the competitive personal computer industry has evolved so that for that price, you can get a computer with multiple cores and a clock speeds over 1,000 times faster, and memory that's literally over 1 million times greater than what it had. So of course there's been huge technological progress, and had a monopolist just frozen things, that would hardly be proof of a lack of monopoly. Now, having talked about some of the common things, let me move on. I mean, given this, I think, frequent and persistent mischaracterization of the consumer welfare standard, let me say a little bit about what it means to me, which I think is largely, I don't think we are going to have much of a debate on a lot of this. It's the same as what Elyse would say, is that it includes long-run considerations, it includes quality, it includes innovation. Now, that said, I do think sometimes both the parties in cases and the courts may focus, I think, too much on short-run price effects because they are the easiest thing. And that doesn't mean they're easy, but the easiest things to predict or determine. But something else I think needs to be taken into account, that firms can be consumers. I think there's pretty widespread agreement on that, but I have actually been involved in litigation where the other side tried to say that even though firms were the purchasers, that's not what, they weren't consumers. I think is actually far too narrow a reading. I also think, and I know some people think this is left-wing lunacy, but I think it should be interpreted as including trading partner welfare, which is to say that when we talk about the consumer welfare standard, we should also be concerned about the welfare of sellers. Okay, but now let me be clear, though, about what I mean by that. I mean that sellers should be entitled to the benefits of competition on the buyer side. I manifestly and distinctly do not mean that we should be trying to prop up firms in the role of sellers and protect them from competition. I mean they should get the benefits of competition from the other side. Because that's one thing I also think is something of a misconception by a lot of people in this debate, is we don't have a purely welfarist standard, right? Whether it's consumer surplus or total surplus. There is a critical element in American antitrust law saying it's harm to consumers brought about by harm to competition. And I think that's critical, and I think that principle, though, readily extends then to saying that sellers should also get the benefits of competition among buyers to be their buyers. And I think it's particularly important because the rise of multi-sided platforms, and both in our economy, but also then in antitrust, because the distinction between a consumer and a supplier is often blurred in that. I mean, if you think about media-supported platforms, where essentially paying in kind to get people to pay attention so they can then sell the product to advertisers, you can think of the viewers or the users as suppliers to that platform. And similarly with credit card networks, where they may pay cardholders to be on the platform, you can think of cardholders actually as suppliers of services that the platforms ultimately are selling to merchants. So I think it is important to expand it. As I say, it's critical, I believe, that this notion of harm to competition, and I will say it's sort of in passing, it's unfortunate that we don't have a good general definition of what harm to competition means, given how important it is. I think we are in the thing of sort of people say they know it when they see it. Now, Robert Bork, in fact, did try to define what he meant by competition or harm to competition, and did it in terms of harm to consumer welfare. And I think the modern day champion of that is Steve Salop, who may seem like strange bedfellows, has pushed that there should be a consumer welfare standard. But I tend to agree with the pushback on that, that if we really meant we were going to evaluate practices by the net effects on consumers, that's just, when you start putting that in the broad context of the overall economy and all the different feedback effects, I think would just create way too much uncertainty. And that's why I think we narrow the focus and look at things like through harm to competition. So let me just mention a couple of other things. In terms of consistency with economics, I mean, I think a lot of different goals could, in theory, be consistent with economics. Consumer welfare is not the only one. And I think part of it is because a lot of times in the debate, we lose sight of what economics can do versus what economists talk about. So I think what economics does is at least two roles in the policy debate. So one is that economics can be used to figure out the link between market participants' conduct and the market outcome. And that should be true whatever you think the goal is, right? And I think that economics in that way should be viewed as technocratic. It says, if the firms or consumers behave in a particular way, what is that going to mean for the outcome? And that's what economics does, is it studies market equilibrium. Second thing that economics can do is help inform policymaking in the sense of saying, if you tell me what your goal is, and you tell me what your policies are, or the decision rules you're going to use, I'll help predict whether or not your policy is actually going to satisfy the objectives that you've put forth. But what economics is not doing in either of those roles is telling you what the goals should be. Instead, it's saying it's acting as a set of tools to help you figure out sort of how the world works and then how your policies will influence. So, as I say, it doesn't specify what the goals should be, and so I think economics is completely consistent with having multiple objectives and socio-political goals. Now, that said, I want to be very clear, I don't think that would be a good thing. I am a supporter of the consumer welfare standard, and I think we should keep it. But there's not an economic theorem that says that. That's really based on practical experience and in the history, as Elyse pointed out. It's not something that economics itself says should be the case. And where this leads me, and wrap up, is I think that the left is, and the neo-Brandesians or the people on sociopolitical are really attacking the wrong things. I think the consumer welfare standard is a good standard. I think trying to protect small businesses, or what it, I think would devolve to in the US is protecting the small billionaires from the big billionaires, would be a serious mistake and lead to a lot of unproductive rent seeking. Okay. I also think it'd be a really serious mistake to abandon economics, because I think economics does provide the best set of tools we have for linking policies to outcomes and ultimately to whatever your measure of social welfare is. And so I think it makes no sense for either side to advocate, and which has typically come from the left, to abandon economics. Now, that doesn't mean, though, that I believe there's no need for reform. I do think there's need for reform. I think that the courts have gotten to a place where they've actually committed, and particularly I mean the circuit courts and the Supreme Court, several economic errors, which I think are quite serious and I think are leading to bad decisions. And I think that's also true of presumptions that the courts have adopted. And I think it's time for a reset. That's, the law has evolved, as many have observed. Antitrust law is really common law, but it's statutory common law, and so there's a role for the legislature to reset. when the legislature thinks that the courts are no longer in line with what at least the current legislature intends. And I think we're at the time where that should be happening. So what I think we should be debating is not abandoning the consumer welfare standard or not. I think we should be debating what would that reset of presumptions look like. Let me be clear, I do not think that the current anti-big tech bills in any way, shape, or form look like what that reset should be. And I think we also need to consider other reforms, such as greater use of court-appointed experts or having written expert testimony, or what they use in Australia and New Zealand, what's known as an expert hot tub, where you put the experts in front of the judge simultaneously and you let them go back and forth and interact. Because I think there's a range of process reforms that we could have that could improve the use of economics in the courtroom. Thank you.
Thanks, Michael. The mention of expert hot tub conjures up images that are quite unpleasant.
Okay, you may not want to visualize
Yes,
it.
I do. I cannot imagine how that is. You mentioned something that is, I think, is critical to this debate and largely part of the misunderstanding of this, unfortunately, heated debate between different political ideologies. But what are the elements? What are the concerns of consumer welfare? Price effects being one, but you mentioned them. I just want for emphasis so the rest of the folks can understand that who might be watching this later.
So I would say, it's really I think the full range, I got to be careful because somebody on the left, no, that just shows you're an economist and you have your blinders on. The full range of effects of what occurs in the sale of the products and the consumption of them. So, it's looking at as I said, the price. It's also looking at the qualities of the products. It's looking at whether competition in the market's driving innovation and driving various forms of investment. I guess what it's not doing that some of these people would like is being against concentration for its own sake, being just flat out against it, which people sometimes put forth, for political arguments, saying, well, we don't care if the market's doing well in terms of satisfying customer wants and having low quality, low price, high quality products and constantly innovating. We just don't want there to be big firms, or we're worried about what's happening to workers. And there I want to distinguish two kinds of effects. Let's suppose there's a merger that's proposed. I think that, and not everyone who supports the consumer welfare standard would agree with me, I think that the consumer welfare standard should protect workers from a merger where the effect of the merger is to lead to a monopsony, right? To lead to a single buyer for the workers' services and deny the workers a competitive market for their labor. Now, of course, there'd be a lot you'd have to look at to see whether the merger in fact did that, because there may be lots of other potential buyers of the labor. That sort of effect, though, I think can and should be included within the consumer welfare standard. What's a very different effect, which I would not want to include, is to say, no, we just care about workers, period. And so if as a result of the merger, the firms will combine intellectual property in a way that allows them to be much more efficient and produce more output at lower cost with fewer workers, there are people who would say that's an argument against the merger. And I think, again, this is not something economics proves, but this is my view, as an economist and as an old guy who's seen a lot of stuff, that it'd be a really serious mistake to adopt that sort of view, because you're then basically against technological progress, and that while it might benefit the employees of those merged or non-merged firms, as the case may be, in the short run, overall, I think it have bad effects for the economy and for workers overall. So I think, it's in some ways you got to talk about what it is it doesn't include. And I think it is these notions of, either sort of the political power aspects or certain things where it really is just about certain groups getting economic rents or payments as opposed to the outcome of the competitive process in the market.
Thanks for that. And that clarification is important, partly because the consumer welfare standard is criticized because they're saying it only measures price effects, which is just simply not true. Bilal.
Okay, so I think I'll be much shorter than my two panel members, mostly because I think I agree with a lot of what they said, but also I wanted to take a slightly different approach and raise some questions that maybe will come up in the discussion. You know, most of my time has been spent sort of as a practicing attorney, either in private practice or in effect in the government. And I don't quite know what is meant by the consumer welfare standard in practice, outside of identifying for the courts or for clients, or clients identifying for me, you know, sort of the efficiency justification for a practice or a merger. And I think that is really where the focus might, well, this is where I think the debate might be focused on, is how best to identify and measure efficiencies or benefits associated with a transaction or conduct, and then asking, as the court did in the Microsoft matter, you know, how to balance those effects, positive effects versus any negative effects from the conduct or the transaction. And I think this was an area where then Professor Bork and then Judge Bork was sort of deficient, right? And that, you know, my recollection and my brief review of the Antitrust Paradox over the past couple of days suggested that, you know, Judge Bork was very good at identifying efficiency justifications for practices, and thus he was very successful in helping overthrow the old order, where efficiency justifications were not either considered or sometimes held against parties to a matter. But he was not very good at putting forth a framework for balancing those efficiency gains, let's say, against any costs from conduct or a transaction. And that's not meant to be a criticism, I think, or a harsh criticism. I think Bork, more than anyone, was instrumental in showing the weaknesses of antitrust law, particularly as it developed, you know, in the 40s, 50s, and 60s. But his failure is the same failure that I think exists today in the agencies and the courts, which is a failure to analyze clearly both the benefits of conduct or transactions and balance them against potential costs from conduct or, you know, exclusionary conduct or mergers that remove a competitor. And I think this is probably where the debate ought to go, not sort of a more, let's say, obtuse debate over what is the consumer welfare standard and what's an alternative to it. The focus ought to be on, you know, measuring benefits and costs of transactions or conduct and figuring out how to evaluate them and balance them. And of course, that's an area where the economists are ahead of the lawyers, but most importantly, they're ahead of the courts. And this, I think, would be I don't think much of the legislative proposals that have come out of Congress, but I think a direction, a clear direction, that the agencies and the courts better evaluate and balance efficiency justifications against costs of conduct or transactions would be the most useful statutory change that could come out of Congress. And this is not meant to suggest, or this should not be viewed as suggesting that, you know, this is defendant or respondent. The courts have failed. The courts have accepted efficiency justifications and stopped their analysis, sometimes in Section 7 cases, but more so in Section 2 cases, and not done the hard work of evaluating whether the efficiency benefits are sufficient, in a sense, to swamp maybe the negative effects of certain transaction or exclusionary conduct. And And you see that, I think, in the Supreme Courts and maybe the lower courts sort of focus on, concern about false positives, that is challenging conduct or arguably a transaction that may be efficient, and almost no focus on not challenging conduct that may have negative perspective. So I think the direction ought to be harder analysis of benefits and costs, clear direction that the courts and the agencies should do that, and also some direction that the point of antitrust, as an example, is not to minimize sort of type 1 errors, but to minimize the sum of the errors of type 1 and type 2 errors. And I think that would help address many of the concerns about under-enforcement without expanding the factors that the agencies or the courts are supposed to take account of. And those would be relatively simple adjustments to make to the statutes, and then they would be sort of hard to implement, but implemented through the common law process, which I think is, after about 60, 70 years, did start to serve antitrust well. So I'll stop there. Well, I'll make one other point. I just note that some of the attacks on the consumer welfare standard are basically attacks on Robert Bork. And for reasons that maybe we can guess, he's become sort of the boogeyman of antitrust. Now, I said just earlier, Bork did great service and was the most important person in a sense, overturning the old order. But I'd put a question to everybody here. That's a question somebody put to me, which is, Bork is important, but in practice, who do courts cite? Who do associates and partners look to for guidance? Is it Robert Bork in the Antitrust Paradox, or is it some version of the Arita, Turner, Hovenkamp treatise? And Bill Kovacic and others, but Bill in particular, have written significantly on the Chicago School versus the Harvard School, or the Chicago School and the Harvard School approach to antitrust. And it does seem clear that some of these limitations in the sort of generic statement of the consumer welfare standard have, I think, led to the courts focusing more on what came out of sort of the Harvard group, including Stephen Breyer, than Robert Bork in the actual practice of antitrust law. The only, I'd say, coda to that is Bork's opinion in, Rothery, the Van Lines joint venture case was, I think, really the best Section 1 opinion up to that time. And, I'd like to see that approach developed further with this greater evaluation of costs and benefits. Because if you go back to Rothery, you see Judge Bork identified, here are the benefits of, sort of the restrictions, but didn't measure them against the potential costs. And that's really to me, the challenge of productive antitrust going forward. Okay, so I'll stop there.
Thank you, Bilal. I'm going to read two passages from Judge Bork's work that occurred 20 years between one from his book, 1978, and later an op-ed that he wrote that many of his critics seem to overlook. That was an op-ed in 1998 in the New York Times, no less. So Judge Bork explained that rules at the time, quote, significantly impaired both, this is the antitrust rules of the Supreme Court, the precedents leading up to the 70s, quote, they significantly impaired both competition and the ability of the economy to produce goods and services efficiently. That was his main focus. The source of this harm, Judge Bork noted, rested in the lap of the judiciary. he explained that, quote, the Supreme Court, without compulsion by statute, and certainly without adequate explanation, has inhibited or destroyed a broad spectrum of useful business structures and practices. His main focus was to try to provide the neutral principles of how you look at antitrust law so that you do not lose that efficiency. And his interest, in, I thought what motivated his consumer welfare standard was exactly that, more efficiency and the types of business practices that help consumers. He explained, quote again, the responsibility of the federal courts for the integrity and virtue of law requires that they take consumer welfare as the sole value that guides antitrust decisions. The antitrust must employ economic reasoning, follows, of course, from the identification of consumer welfare as the law's sole legitimate goal. Now, he gets criticized that somehow those principles of the consumer welfare standard that Michael laid out and others have inhibits the ability of law enforcement to control some of the concentration of power today. But 1998, in his op-ed, and I'm just going to take a sentence from that, he writes, quote, there seems to be a widespread impression, and this is around the Microsoft controversy, that the Microsoft controversy should be resolved by an ideological litmus test. Liberals are bent on punishing success, and conservatives must defend Bill Gates' company from any application of the antitrust laws. But the question is not one of politics or ideology, it is one of law and economics. And that is why an outspoken free marketer like me can be found arguing against Microsoft. Now, I don't believe, and some would argue, that he was at war with himself in those two, during that period. But I think, as you have explained, some folks, and Bilal, you mentioned that, some folks are trying to, I think, identify the problems with today's economy, with a handful of maybe companies that have a lot of market power, and try to identify it with Judge Bork and say the problem with antitrust law today is that, and they're trying to change the consumer welfare standard. Is that a fair characterization? Did Judge Bork change his views over 20 years, or was he consistent perfectly with his Antitrust Paradox book? Hello.
So I think Judge Bork was consistent, in that focus. I think his focus had always been on understanding the efficiency justification for conduct. I think in the book and in his prior writings, he minimized the potential harm from what I'll call, exclusionary conduct. In part, I think, because the courts had not been very good at identifying, actual harm from such conduct. In the Microsoft case, I think he went beyond what was in the text of his book and could identify the harm from the exclusionary conduct, and basically was suggesting, I think, that you would balance the harm with the efficiency justification or the effects of the efficiency. So in that sense, I think he was very consistent, and in fact, it's sort of the way antitrust should continue to evolve, which is having identified that there were business, non-market power related justifications for conduct or transactions, we ought then move to evaluating, the effects of the benefits versus the negative effects. So I think in an actual case where he was, had a client, and I don't. Or was practicing, he had to do that, just like other lawyers do, and I think he saw that just discussing the efficiency justification for conduct was sort of insufficient when faced with sort of an actual live Section 2 case.
Michael, you were also the chief economist at the Justice Department around the time. I don't know if you had any role in the Microsoft settlement itself, but at the time, at the turn of the millennium, you were there. So, but I'm not sure if you were involved with it before or after, but would love to hear your views on that.
First, I have to say, actually, I was not involved in it at the White House insistence, I am told, but I was not told that by the White House, which did not stop a nationally syndicated journal from claiming journalists from claiming I was the mastermind behind the whole thing. But anyway, so in terms of consistency, I think a couple of things come up. First off,
You mean the White House directed antitrust enforcement at that time, or in settlement?
you may be careful when you say that, because I was a member, was in the Bush administration.
Yeah.
But anyway, in terms of, but Bork's position, one of the things he also said in that New York Times editorial letter, if I remember correctly, is he said, no, I have, this isn't new for me. I have been consistent. 20 years ago, at the time he wrote this, that he had said he thought Lorraine Journal was correctly decided. And so it wasn't that he, never saw an antitrust violation. He said it depended on the case. Now, the one thing you might, I hadn't thought about this before, but it's partly because of something that Bilal was saying about, Bork, though not coming to grips with how to balance things, that I think in both Lorraine Journal and Microsoft, he didn't see a need to balance, because he said reason I'm against the defendant in both these cases that came out is because there was no justification on the other side. There was no balancing to do. Right. And so I think in that sense it's consistent, and I do share the view that, I think that Bork did the country tremendous service in a lot of ways in reshaping antitrust, but I also think that he didn't do enough to recognize there was this need to balance, and that I think he sort of in some sense overreacted to the state that he was seeing, and it worries me now that we're actually seeing the same thing. We sort of keep going too far back and forth each way.
Elyse?
Yeah, I think,
Thoughts on
I
either
agree.
of those?
I agree a lot with, what my co-panelist just said, and, with what Bilal was saying about, Judge Bork being consistent in, wanting to use the economic toolkit that we have, and in particular to aim that toolkit at the consumer welfare standard. And I think that's another thing, we're seeing, again, today we've talked a lot about the different misconceptions that we're seeing, and one of them, again, is that, if you believe in the consumer welfare standard, that means that you never see an antitrust case that you like. You are always siding with the defendants or the businesses. And I think, again, that's really not the case. It just gives you a better way to actually analyze what's going on, to look at what's actually happening to competition and consumers in the market, so that you can, see cases that you do like. And as we continue to deploy this economic toolkit, we've gotten, it's gotten better over time, right? Our ability to assess what the effects are in different cases is certainly better now than it was a few decades ago. As Michael said, there's a lot of looking at prices in these cases, and that's because it's often the easiest, but that doesn't make it easy. A lot of, what you see in these cases is, courts and agencies struggling, because a lot of the times, these are hard questions. The cases that we see the agencies struggling with, in particular, the cases that actually get to court, are the ones that are tend to be the most difficult, and that's why they're at court. That's why, the parties haven't already entered into a settlement. And I think that's one of the things, again, in this debate, there's a bit of a disconnect, I think, between what actually happens on the ground at the agencies and, the public perception of what's happening, because so much of the work happens before you even get to the courts. And so the courts are seeing a small sliver. And so if you're even just trying to look at the cases today, you might think there's a disproportionate emphasis at the agencies on price and short-term price effects in particular. But having, had the benefit of being able to work at both the DOJ and the FTC over the last several years, that was certainly not my experience, right? Like looking at cases, there was not a single case at either agency that I saw where, the staff came to us with their recommendations and said, all we looked at is price and this is what we decided, right? They were always looking at, innovation, really diving into and grappling with how is it that the companies are competing in this market? Is it on innovation? Is it on quality? How do they think that they can get more customers? How do they react to their competitors, their different moves? So one of the things I did a little while ago now is, I looked at all the merger complaints the DOJ had filed between January 2019 and September of 2020. And again, this is, just a small sliver of the cases that actually got filed. The parties hadn't abandoned them, all of that. But not a single one of them alleged only price effects, right? They also included things like, negative effects on quality or reduced innovation or R&D or, different, services and quality were going to go down. So I think, there's a lot going on that we're able to do now. And so that leads to, you being able to be pro-consumer welfare, but also seeing antitrust cases that you think, where you think the agencies need to step in.
Exactly. And you certainly were unique in that not only did you serve in Article 2 of the Constitution, the branch, but you also served in Article 4 of the Constitution in the FTC. Let us move over. So one of the things I would, when I was at the Justice Department, I'd get calls the last couple of years in particular, at least 3 different members of Congress. So how would you help us? We need to repeal by statute the consumer welfare standard. How would you provide technical advice to do that? What do we do? There's this thing. And then it started, kind of a process of education of what is the consumer welfare standard. Part of that was this misunderstanding that it only concerned price effects. And Michael, you mentioned there's a handful of presumptions that are created by statute. So there's 2 lines of questions related to that, especially relevant to today's debate. First is, and let's ask the panel about this, is what would be the types of statutory changes that would be consistent with the consumer welfare standard, but would be changes that would be acceptable and improve enforcement of antitrust law consistent with economic understandings? Michael?
So I think one area, and I think the laws have evolved to the part that it's too hard to bring a case based on potential competition. And this is something that's come up a lot with big tech and the concerns that they buy up potential competitors and thus stop it. And there are an awful lot of big tech mergers that has nothing to do with, but there are ones where you can suspect that was the rationale. And my understanding is, as a practical matter, it's near impossible to bring such a case, and I think that should change. I think there are reasons to believe that, especially in some of the tech markets, it's possible to identify a firm that's a threat fairly early on. And one of the reasons is because a lot of these markets have network effects or data economies of scale or whatever, where in order for a firm to displace an incumbent, they typically have to have an innovation that gets the ball rolling, and then they have to have favorable consumer expectations, and then the thing snowballs because people say, oh, this is say the social network I want to be on, so I'm going to join it, and I expect everybody else to, and off it goes. And it may be possible then to identify a very small number of firms that look like they have that momentum starting when they are still very small. And I think we need to adjust our thinking, and presumption is probably the wrong word, but I think there needs to be a reset there so that, in fact, nascent or potential competition does get more attention. I think there's a need, in terms of presumptions, I think there should be a reset for the courts to be more neutral about vertical restraints. At least some of us have a sense that there's an incredibly strong presumption or prior that vertical restraints are good, that is leading the court sometimes, I think, to underestimate the potential damage. So anyway, those are a couple where I would like to see a reset. Although again, I would like the resets to push things towards what I would see as more neutral, as opposed to, for example, in some of the big tech legislation says, well, okay, every merger is bad. I think that's a mistake. I want to be able to look at the mergers individually and say, well, this one we really are concerned about nascent competition, and now we're going to have a detailed analysis, as opposed to moving from what I think now it's too hard to stop such a merger to just having a blanket prohibition.
And specifically with the potential competition, now, at the Justice Department in the last couple of years, we brought two cases. One was Visa's acquisition of Plaid, which was not in the market, and then the other one, which was litigated, was the Sabre Fair Logics, both of which had elements of potential competition and certainly not the market share analysis for the changes. But you're right, it's an uphill climb for the enforcement agencies and plaintiffs. But what specifically would you change to allow for that would not have the counter effect of some of the pending legislation that could account for that? And my guess is the poster child for what we're talking about and some unfortunate emails and others that happened with the House Judiciary is perhaps Instagram, Facebook's acquisition of Instagram, that I think the general public has been captured with. Had those two been competing with each other, maybe we would have a better environment. But there's a lot of arguments for and against that. But when we're talking about the nascent competitor, what would be the specific change?
So let me say, I'll admit, rather than duck the question, I don't know what the specific change was. Well, let me use Facebook, Instagram as a hypothetical, because one of the things I can't stand as a testifying witness is hear people explain to me about a case they have not been involved in, and turns out they don't know the record. So let me do this as hypothetical. I think at the time that merger occurred, had the FTC tried to block it, because they've gotten a lot of criticism for not, they would have had zero chance of succeeding in court, both because of the standards of the day. So I'm not sure what the legislation would say, but let me just say a little bit about what the process would be that I think I would like to see the agencies, and then if it were to be litigated, the courts go through. And it would be to assess, if you saw the merger, and unlike a lot of economists, I would actually look at intent. I mean, you have to be very careful reading documents, but if you see a company and the CEO and dominant shareholders say, we've identified this company as a threat and we should, buy them to neutralize them, I think that should get some weight. But I think you would then want to look, are there other, how strong are the other potential competitors? How big are the effects? Look at the type 1 and type 2 errors and ask, okay, how big a deal is it? And one of the things I would say about this, people here are used to the term talking about Schumpeterian competition, but it's something that often came up with the Microsoft case, which is the idea that we have these, particularly in big tech, we have these markets with a lot of intellectual property, say network effects, all these things, importance of data, give rise to big economies of scale. So at any one moment, we expect one or a handful of firms to be dominant. And the way competition takes place is new firms come along, they innovate, and they get the positive feedback and scale all working in their favor, and they replace them. So you have these successive generations. Now, some people have used Schumpeterian competition as argument against antitrust enforcement, saying, look, you see a firm that looks dominant today, but they could be swept away. And so you shouldn't take the fact that they have such a big market share to mean that they're entrenched. However, if you take that view, and I think there's something to it, then you also need to take the view that that little teeny firm is not inconsequential, right? Because you just told me, well, market share is the wrong way to look at things. You can be swept away by some nascent competitor. Well, that means then we should be concerned if you start buying those nascent competitors. So I think basically, all I can say at this point is you have to sort of dig in and look at the facts and the potential and for them to emerge as a competitor. And I think you also need to understand in some of these markets, it may be that you should block the merger even if there's what seems intuitively like a fairly small probability that that firm would be the winner, because we're talking about things where it may be tens or hundreds of billions of dollars on the line. And so you can multiply a number like that by a small probability, and to anybody but somebody in the US government, that looks like a really big number when you're done.
And writing statutes are hard. And that's why I think Congress has shied away from writing too many antitrust statutes and deferring to the development of the common law. Bilal, are any changes? Now, you ran the FTC's policy shop, and you had to think about these. How would you improve the consumer welfare standard if you had to?
Well, I think I'd go back to a few things that I mentioned earlier, which is, first, I don't think prescriptive statutory language is useful, and I think it would be hard to develop. I don't think we should switch burdens. The burden should remain with the plaintiff to prove its case. I do think some direction to the courts and to the agencies through statutory language could focus on a better sense of this type 1, type 2 error issue. The courts have adopted type 1 error as sort of the standard to avoid, and I think it would be useful, if it has to come from Congress, it would be useful for Congress to make clear that the antitrust laws, that the idea is not only to avoid false positives, but false negatives. And it might look odd to put sort of the language of type 1 and type 2 error into a statute, but I think that's the biggest change. That's the change that over time will have the biggest effect. And it would, in a sense, force balancing. And that's about the only change I would like to see. I think the agencies, if we all think there are potential competition cases that the agencies are, not bringing because it's too hard to bring or win a case, I'd actually like to see them bring those cases and develop a record, in court as to why they believe a firm is a future or potential competitor. That would have an effect on competition, in the relevant market. I think there's the case law from the 80s, I think, does set a relatively high bar for some potential competition cases. There's a sense that the level of certainty of entry, by one of the parties to a merger must be relatively high. I think that is a problem because antitrust does not only focus on high probability events, or shouldn't focus on only high probability events. But I'd say the FTC has, in my reading and in my understanding of some of the cases they've brought over the last 25 years, actually brought what I'd call potential competition or future competition cases with a fairly low level of certainty that one of the parties to the transaction would enter the market. So I would like to see more cases brought because I think we've all sort of said the agencies ought to bring more potential competition cases, or the courts ought to allow more potential competition cases, and that there's a hurdle to doing it. I'm not convinced of that. I think with a good story as to why someone is a, effective entrant, the courts can be convinced. We'll see if that happens in some of the cases that have been filed already. But ordinary course cases that the FTC has brought over the last 25 years and received consents on do look a lot like low certainty potential competition cases. And it's not only in the pharma space. To me, a great example is, Arbitron Nielsen, right? Neither of them had a product on the market. They had arguably capabilities. How could how could anyone believe, both parties were likely to enter? That was a case of very low probability. The other thing I'd like to see the agencies do is allege more technology markets. I found in the last 25 years 3 FTC cases that allege technology markets in mergers. 2 during my time with Tim Muris, 1 I think under Patofsky. I think that's an area that's sort of underdeveloped, particularly as we talk about the technology space. Somebody ought to give some thought to whether alleging technology markets and harm to technology markets makes some sense there. And I would make some changes to the Hart-Scott rules and potentially the HSR statute, but particularly the rules, so that transactions that involve small but growing firms, whether US-based or international, are captured through the reporting process rather than exempted either by statutory language or by Hart-Scott rule. Some of that comes out of our work in OPP on the 6B study, the evaluation of what I'll call, well, what were non-reportable acquisitions by, five large technology companies. Those changes and the bringing of more cases, I think, are, more important than specific prescriptive language in the statute. I do think a direction from Congress about balancing and, not just being concerned about type 1 error should be there. I mean, the Supreme Court has said we're focused on type 1 error. There is no, basis for that. Any good economist will tell you we minimize the sum of the errors, type 1 and type 2, and maybe the Supreme Court needs to hear that from Congress. But that's about the only change I would make at the statutory level.
It seemed like Judge Bork was okay. It was one of his criticism of the past antitrust doctrine was the fact that the court was making things up without, as he wrote, without compulsion of statute or really explaining it. So if Congress, compelled a certain kinds of analysis, I think that would be consistent not only with his philosophy, but that's an appropriate policy-making body. But it seems like you would like to see it develop organically. I have no idea, having been the chief counsel of the Senate Judiciary Committee, how you would write a statute that would say, do this balancing by the court. But that's the hard part. It's, as Jack Valenti famously said, you can tell a man to go to hell. Getting him there is a whole different story. It's hard.
Actually,
Michael?
you're asking about specifics, and I didn't give this example before because I thought maybe it was viewed too much as a technical point, but I do think this is something you could put in the statute, which is to reaffirm that you could establish a firm has market power by both direct and indirect means, and that market definition, I think the statute should say it's never required that you absolutely have to do formal market definition, and that in fact, if you can establish market power or the effects through direct evidence, that should be good enough, and that would be going to directly against my understanding of part of the American Express opinion of the Ohio, where they said with vertical practices that you have to define relevant markets. I think there's no support for that, certainly in economics, if by relevant markets you mean what I believe the court meant, which is you define this concept that has this stark 0-1 boundary. I, of course, as an economist, believe you need to understand the boundaries of competition and how competition functions. But it's my experience certainly has been that the formal process of market definition and trying to divide these bright line boundaries where they clearly often do not exist is becoming more of an obstacle to good analysis and judicial decision making than a tool.
Talk about bad cases making terrible law, and that was one. But, Elyse, one other point I wanted to ask about is we've been talking about, antitrust Bilal specifically advocated continue to be developed without formalistic rules and prescriptions, and letting the courts decide this. We're in a stage where the Supreme Court is a textualist and originalist court. And again, largely from yet another influence of Judge Bork and his originalism and having certain principles. But Justice Kagan announced, we're now all textualists. We have a new configuration of the Supreme Court that hasn't had as many antitrust cases. They've had, the American Express, but the NCAA recently. If they're going to be textualists, from the text of the Sherman and the Clayton Act, what does this mean as new cases go up to the Supreme Court? What are we looking at? Are we looking at per se rules for Section 2? I mean, that certainly could be derived from the text if the court really wanted to. Cases like Philadelphia National Bank in the merger world, you have certain presumptions that have been kind of made out of whole cloth. Are those in danger, the next merger case that the Supreme Court takes? It certainly was the type of stuff that kept me up at night at the Antitrust Division. But tell me what you think the court would do currently, this makeup of the court, if we were to predict. And how do you address the consumer welfare standard with a textualist, originalist court and a statute that's 2 sentences?
Yeah. So I think that's, again, a really interesting question. And I think why, time and time again in the antitrust discussion, we, see folks coming back to, okay, well, what's in the legislative history? Because again, there's so little that's actually in the statute for you to go off of. And I think it was, I don't have the data in front of me, but pretty early on in the history of the antitrust law and the Sherman Act in particular, there was, a government report saying, already the legislative history has been exhausted. There's all of these arguments already being made. And that was, again, even before the Antitrust Paradox, before a lot of the papers recently that have been written saying, trying, especially from the neo-Brandeisian side, right, trying to argue why Judge Bork got it wrong on the legislative history, and it really says all of these other things. It's something that keeps cropping up, and I think at the end of the day, though, again, it's not very informative one way or the other, as you can see from the flip-flopping back and forth, and all of this throughout the over a century now, right? Is that it's not giving us a lot of information, and to kind of go back to what we talked about earlier, I think what has been a lot more informative and helpful is actually looking at the case law, looking at the cases on the ground, and seeing how those have developed over time. And I kind of like to, pick up on a point that, Bilal was making in terms of, actually getting more cases in front of the courts, I think is important, because we saw the courts had this really important role in helping get antitrust to where we are today, where, it's certainly not perfect, but I think, it's much less at war with itself by any definition than it was in the middle of the 20th century. But the courts can only play that important role if they're actually seeing the cases in the first place. And Megan, to kind of your point, it's one of those, would love to see the Supreme Court get a merger case and actually be deciding one of those. That hasn't happened in several decades. So it would be, I think, fascinating to see what they would decide to do there and what they would want to do with P&B. I expect, even being textualist, there being so little to go on, that there would be a lot more focus on, okay, what is the consumer welfare standard? What does it look like today? And is there a basis for this particular presumption that's in front of us now? So I think there would certainly be a lot of, questioning what the current law is and how best to implement it. But I don't know that the textualist arguments do a lot of work for you in those cases.
It's hard bringing cases. As you know, it's hard being a plaintiff in antitrust cases. Justice Gorsuch described this as during confirmation hearing, and you're a defendant. There's multiple ways to knock out a case to do that. And the same thing at the 2 antitrust agencies. And as you observed earlier, there's a lot of other reasons why you don't go to court. You can't just look at statistics of cases brought, partly because parties abandon cases. They've got other pressures. They look at where else they could deploy their resources and capital and other acquisition. And so there's a lot of reasons why agencies cannot, and may not have the opportunities to test some of these theories from an academic standpoint, because there's always a settlement discussion or abandonment or some other form. So it's hard to see those types of cases develop, and the amount of resources that merging parties are willing to give. So I was a big advocate of Congress, at a minimum, codifying certain presumptions that has worked to provide predictability for both enforcement and merging parties. At a minimum, that's some things that they could do without really screwing up future enforcement and making it more confusing. Yeah. But we'll see if that ever happens.
Macon, I want to disagree with that a little bit in terms of, well, at least the point about it's difficult to bring cases.
Difficult to bring cases that could win.
Sure. So yeah, fair enough. So look, I'm going to talk about stuff I know about, and I don't mean to sort of exclude others' initiatives. 20 years ago, when I was at the commission, when Tim Muris was chairman, the agencies had lost 7, 8 hospital merger cases in a row. DOJ appeared to have gotten out of the hospital merger challenge, business. And the commission started, a program to find consummated hospital mergers, to try in-house through the administrative process to develop a record as to how hospital mergers ought to be reviewed. That, I think, took some time, but has been largely successful. I don't see why the commission cannot bring potential competition cases in-house over the current and maybe the next administration and try to develop a doctrine of potential competition through, its own processes and eventually the appellate process that further develops the law in a way that might be sensible and can withstand appellate challenge. There are a series of cases from the 80s, potential competition cases, where the standard, for entry, in a sense, likelihood of entry is quite high. If the agency or agencies believe that standard is too high, the commission, as an adjudicatory body, is in the position to try to convince an appellate court, through a commission opinion, that those standards are too high. And they ought to do it rather than asking Congress, in my view, to change presumptions when, in fact, the cases the agencies bring, they don't often lose, right? So it's easy to say we don't bring cases because, the burden's too high, the risk is too high, that we're wasting resources on losers. But I think that's, in some sense, maybe in a large sense, a cop-out. I have some questions about, sort of the commission structure generally. Not this administration or some other administration, just generally. But they do have the option to bring these cases in-house and try to develop the law and bring that, eventually sort of bring that to an appellate court. And they ought to do it. And they're not. I mean, there is a reason, I think, that the Facebook case was filed in district court, but it was those focused on consummated mergers and conduct that I think the commission lost an alternative to sort of develop a treatment there, how the law should develop by not bringing it in-house and using their own, I'll call it expertise, to move the law forward.
Yeah, and I don't mean they don't bring cases only because they're hard. Of course they're hard. Yeah. It is that a lot of times other parties have ideas. They abandon the case.
Oh, yeah.
They'd be willing to give a tax. Now, I think what you said highlights one of the biggest issues that I have with the structure of an FTC, where it's to develop the law. If the law is to be, they're either bound by the law or they're not. It is not, I don't believe, the function of the FTC. Maybe I got to go read Article 4 of the Constitution again, but maybe they do have that legislative power. It's really up to Congress to do that and to tell them what it is, and to have two different standards, which they do. You can, a lot of times you literally flip a coin and a merger goes to the FTC or the DOJ. And whether or not you can go to court or go to the FTC in the process that Bilal's talking about is going to your administrative law judge after the commission has authorized that case. You go, one of the benefits is you go within 8 months, you try your case, and then lo and behold, if the commission loses, guess who it gets appealed to? The commission. The commission itself that authorized it gets to hear the appeal of that case. And then it goes out, after they write an opinion, and it goes out to a court of appeals in that process. There's just something fundamentally from a due process standpoint seems to be problematic. Now, it could provide for, these academic experimentations, but at what cost? And who is the appropriate body to develop that law? If there is a good argument to make that law, and an expert agency like the FTC thinks so, and the standard for potential competition is too high, make the argument to the policymakers, to Congress, and change that law in a process that we have We certainly wouldn't stand it if a foreign country was doing some of these things, but I digress. I'm no longer in a position where I can express those types of opinions with any real effect. Now, are there any questions? You got an illustrious panel with lots of experience here. If somebody has a question to ask about the direction of antitrust law or the evolution of the consumer welfare standard, we can ask them. If not, Elyse, do you have a comment or a question from your call? Oh, we do have a question. Alden.
Very, very interesting discussion. One question about acquisition of small potential entrants, potential future competitors. So I have one question about factoring in the entrant in merger analysis, acquisitions of small competitors. How does one take into account the effects on capital markets, in particular, since often we're talking about innovation, holders of intellectual property, that you might say, well, we need a lower probability that this Instagram or some other firm is going to become a competitor. But what if a heightened effort to block such acquisitions diminishes incentives for venture capital to support the development of intellectual property by small firms that are growing precisely with the goal of being acquired? So that adds an additional level of complexity, but isn't that a serious issue that you'd have to confront if you started bringing a larger number of potential competition mergers involving small entrants?
So I think it is a potential concern, but I also, and that's why, again, I wouldn't do a flat ban. I would look case by case. But I think it's also important to point out that there's a simple model everybody has in mind when they talk about the effects of, what's called entry for buyout, or the effects of allowing these mergers on incentives, which is either you invest in entering or you don't. And then it's certainly right that if you take away merger as a possible exit strategy, it lowers your incentives to invest. However, real world is much more complicated than that, and you choose a multi-dimensional entry strategy. And it may well be that if you lose the option of merger for buyout, where you were going to become you were going to threaten to become a competitor, now you get bought out. In that world, you may actually invest more aggressively when the option's taken away from you, because instead, think about it, you say, look, I just do it again, a caricature of it. If I know I'm going to just be bought up, I say, let me just do enough, let me invest enough so that I can be a pain and I can get somebody to write a check to me for several $billion. Whereas you say, well, that's actually not an option. You're going to actually have to innovate to compete. You may push yourself much harder. So it's just not true as a general matter of economic logic that limiting entry for buyout will necessarily reduce investment incentives. For certain types of investments, it could increase them. But that said, I don't want to diminish it. I think there is a real concern. It's clear a lot of firms are coming up with innovations that they think there's no chance they would ever displace the incumbents. They're not trying to. They're trying to come up with complementary products or pieces of IP. And this is really I think often an efficient way of a license agreement or selling. And so I think we do have to be careful about that.
Yeah, and I think that's kind of reflected in at least some of the cases we've seen the agencies bring so far, in that what they're looking at is, ways to identify, okay, why this particular nascent competitor was going to have some sort of impact on the market. So in the Microsoft case, right, the court is looking at Netscape, and they really say it's, kind of the only one in that space, the only one who's doing these kinds of things. And I think the FTC's argument in the Illumina Grill case that's going on now followed a similar vein. So they're really looking at, it's not a space, let's say with food delivery apps, right, where there's been a ton of capital investment and, just a ton of different competitors in this space right now. They focus so far on, cases where there's, one particular competitor who is uniquely situated to challenge the status quo and the competitors. So I think that's factoring into what they've been doing already is, what the effects on the capital market are.
Right.
I'd ask a question, Alden, to you, which is it so clear that antitrust ought to take that factor into account? Why is that not sort of a broadening of sort of the purpose of antitrust? Why is that not a policy argument similar to, we ought to take income and wealth effects into account? I'm not sure it's the same, because I agree with your point generally, but I'm just sort of wondering why it's an antitrust point.
But doesn't that come to, the consumer welfare standard actually can be an incredibly expansive standard, and it does come, because I take it, the reason you're asking is you're saying, or the way you would put it in the framework, put words in your mouth, obviously you can speak for yourself, but as you say, well, if by, say, banning these acquisitions, we end up leading to less investment in venture capital, less innovation, ultimately that's going to be worse for consumers in these markets.
Well, I agree that makes sense, not banning them, but I just wonder how you take account of that case by case.
But I think that comes to something, I actually wanted to comment on your point about the balancing, which I agree with completely in principle, but the courts have been really reluctant. There's empirical work showing that in Section 2 cases, essentially no court ever admits to having done balancing. But the opinions all say is one side was right and the other side had nothing. And it's not that anyone, I think, believes that, some cases that may be true, but I think, and probably rightfully so, the judges are really worried about being second-guessed, and it's really hard to know how to do the balancing. And I think it's a huge problem we're going to face. But I think it is also something that's inherent in the consumer welfare standard. It can actually be very broad and very vague. One of the attacks on the socio-political goals is say, well, you've got all these goals and they require all these trade-offs. And Robert Bork himself said, well, look, that's actually true. You do have trade-offs within the consumer welfare standard. It's just he thought that they were narrower and you could deal with them in a more, I guess, rigorous or consistent way. But we shouldn't forget, though, that applying the consumer welfare standard actually can be extremely difficult in practice.
Good question.
So much. Stokes Nielsen from Nashville, Tennessee. I represent artists in the entertainment field, and I found some similarities in Bork's book with the entertainment industry. I was hoping to ask you guys a question to get your thoughts on it. American broadcast radio, as it relates to major airplay for music artists, is 95% controlled by 3 major entertainment companies, which are foreign-based companies. What are the remedies that American-based entertainment companies have for fair play as it relates to getting their signed artists equal chances for airplay on American radio? Can Congress or the DOJ apply some sort of assistance to American-based entertainment companies to have equal access to American broadcast radio, especially since it is controlled by the FCC?
Elyse, do you have a comment
Oh, it looked
on?
like Bilal wanted to say.
No, I was going to say I have no comment on that.
Well, as you know, I think specifically what you're dealing with is the public performance rights of artists that is subject to DOJ consent decrees for about 80 years. The DOJ did an extensive review of that. We kind of explained that in a statement that I gave in the last weeks of the last administration about taking a look at that. There's been law that has developed. Those consent decrees remain in play with respect to public performance rights. Of course, sync rights and other publishing rights, others are outside of that, and there's a market for that still remains. But artists had come to the division, as well as some of the public performance rights organizations, to not terminate those consent decrees. But it's a challenge. Now, there's also sound recording rights. This is if, God forbid, I sang, Elton John's written song. That would be terrible, but I would have no rights in the underlying song, but I would have a right in my sound recording of my rendition of that. That's one where artists get zero money from broadcasters. You get money from digital, but you get no money from broadcasters. Congress has introduced legislation year after year with more than 200 co-sponsors. It's never been passed into law. I'll leave it to you to determine why that is the case. But that is an area which is interesting because you have a disparity in the treatment of recording artists as opposed to songwriters and publishers in the treatment of that and remuneration of those intellectual properties. Any other questions? Sir?
Not sure if it's on. Okay, great. Thanks very much. Just a quick maybe trip down memory lane for any of the panelists who would care to comment on this, but I'm curious if you think the consumer welfare standard was ever applied in the early Sherman Act era, even if not so denominated. And I realize how fraught consumer welfare standard, how fraught counterfactuals are, historical counterfactuals, but if it had been applied with respect to the labor market, might it have been might it have had an effect on the formation of labor unions as countervailing monopolies or oligopolies?
Great and interesting question. A subject of the book, I think something that's addressed in the book Titan about John D. Rockefeller by Chernow, which is an interesting read and discusses about labor unions and organization around that. So. But I really don't have a comment about it other than to point out what a wonderful book that is that addresses a little bit of that. Any?
Well, I'll take a stab at sort of the first part of the question. Look, it's hard to find the phrase consumer welfare in Supreme Court opinions, particularly in early Supreme Court opinions. I think an example, though, of consumer welfare opinion, was sort of the development of the rule of reason by then Judge Taft in Addison Pipe. He doesn't use that language, but I think when you move away from, the statutory language of, prohibitions on restraints of trade to turn it into prohibitions on unreasonable restraints of trade, you're applying, some underlying principles consistent with what's in the consumer welfare standard. A little hard. The second part of your question about, labor unions, it is hard to sort of think about how that might have developed, in the early years, but of course, Congress did change the law, I guess, in the 30s that gave the labor unions protection. They've had that protection now for a long enough time. I think if they were going to develop into, sort of a countervailing institution against large firms, that either would have happened already or it happened and then, has sort of dissipated for reasons not related to antitrust. That's an attempt at answering the question.
Yeah, I think it's an interesting question, and you don't really see that phrase consumer welfare standard, I think, in the early cases. I think that's right. What you do see early on, though, is, the court acknowledging, why we have kind of the free market system we have today, right? Like why we think competition is good. So you get some glimpses of, what the consumer welfare standard is and why today we think it's important, right? Is, we think it's competition between companies is forcing them to fight for consumers and that benefits consumers in all sorts of ways. So you get some discussion of it early on, but it's really, I think, very heavily overshadowed by a lot of the socio-political goals that come in. And when the court's actually making their decision, they're relying, in the earlier cases, much more heavily on, well, we think this is going to negatively affect smaller companies or, individuals than on the actual consumers. But you can see early on some glimmers of what comes later.
And I'd love to hear from Professor Katz, because I believe the actual terminology started getting into the parlance through the Chicago School and the work of Aaron Director and Easterbrook and that crowd around that time. But I don't know if it was in the judicial nomenclature until later on. And now we have, I think, by last count, over 100 courts of appeals cases, and I believe 19 Supreme Court cases that cite antitrust paradox and, in some form, the consumer welfare standard.
Yeah, but I would agree with Elyse, and I think actually even in some of the early language, though, talking about the socio-political goals in some ways are, maybe because it's shadows there or something, are actually making reference to the consumer welfare standard in the sense that it's sort of like, well, there was this, but it also would hurt small businesses. And the fact that they're doing it as sort of a but, I think, is because they're saying, well, yeah, they're not using that language, but they're saying it would benefit consumers, but now let's bring in the socio-political goals on top. So I do agree that it was one of the ones that seemed like it was there early on, although again, it didn't have the primacy that it does today.
Well, thank you. With that, like Cinderella, our time is up. If we could give a round of applause for our three distinguished panelists. It was my privilege to moderate this, and thank you, and I think it's time for lunch.